It's my tremendous pleasure to welcome not just Tammy to the floor, of course, but to be the speaker this evening. Most of you would have met Tammy Wong by now. She's had a wonderful introduction to the floor. All the reports have been more than positive, which is wonderful to hear. If you all read the last newsletter, I hope you all did, you would have found out a little bit about Tammy's background. She went to the University of Sydney. She worked for the Redfern Legal Centre, and then she worked for the Darwin Community Legal Centre before she commenced for about 5 years at Bowden McCormack in Darwin, and she worked in the litigation section in Bowden McCormack. But because of the geographical location, of course, she had a fair bit of interaction with Indigenous litigants and acted for a number of them. So Tammy comes here tonight to speak about native title with a particular interest in that area of the law. Just by way of introduction, you should all have a written paper that's been emailed to you as well. I think I've referred to this book before in the past. I have to thank Mr. Kenzie for this. This was a book that he recommended to me. It's by a chap called Watkin Tench. He came out in the First Fleet in 1788. He was 30 years old when he arrived at Sydney Cove, and like a number of people that were on the First Fleet, he wrote an account, a journal of his experience in the new colony. And out of everyone's account, his became the most famous and talked about, and mainly because of the humanity and his love of nature that comes through in the pages. And so he, I suppose, like many people, first came and was slightly, well, he had a preconceived notion of what the natives, in inverted commas, would be like, and he was apprehensive about his interactions with them. But he spent 3 years here, and throughout his time you can actually see in his journals how his appreciation grew immeasurably during his interactions with them. And so I'm now moving a couple of years into his time, and once the colony started foundering in Sydney, they moved out west to what they called Rose Hill or Parramatta, and they started exploring further west to find new pastures to sow and the like. And this is what Tench said about one of his excursions out to the west. He goes, "We expected to have derived from them," he's talking about the locals, "much information relating to the country, as no one doubted that they were acquainted with every part of it between the sea coast and the River Hawkesbury. We hoped also to have witnessed their manner of living in the woods and the resources they rely upon in their journeys. Nothing, however, of this sort yet occurred, except they're examining some trees to see if they could discover on the bark any marks of claws of squirrels or opossums, which they said would show whether those animals were hidden in the leaves and the branches." So they took him out west to assist in examining the area, and they'd expected them to be well acquainted with the land, except it turns out that they knew nothing about that land, they only knew about their land. And this harkens back to, I think, the topic that Tammy's getting to today. And so Tench goes on, "At a very short distance from Rose Hill, we found that they were in a country unknown to them, so that the farther they went, the more dependent on us they became, being absolute strangers inland. To convey their understanding to the intentions of our journey was impossible, for perhaps no words could unfold to an Indian," his words, "the motives of curiosity which induce men to encounter labour, fatigue and pain when they might remain in repose at home with sufficiency of food. We asked Colby the name of people who lived inland, and he called them Buru Berangal, and he said that they were bad, and whence we conjectured they were sometimes at war with those on the sea coast." So there were distinctive areas where people occupied, and once people traversed into other people's areas, then they were effectively expecting to be at war with them. So that's a fantastic book. Mr. Kenzie recommended it to me. I certainly loved it. It's a great read. So Tammy will obviously pick up that thread. Her history, if you've seen her paper, it starts in the 60s when the bark petitions were presented to Parliament, and that led on to the first case that Tammy will discuss, which was Justice Richard Blackburn's case that found that there was no recognised communal native title in the common law of England as received in Australia. And there's been a lot written about whether that was an error or not, or whether Blackburn himself was simply following what was the common law and certain Privy Council's decisions which had held that in the past. And in effect, he was bound to so find. And then, of course, we get to 1992 and what has become the most, I think, famous decision, certainly affecting the common law in our country. And Tammy will discuss that, but obviously Mabo left us with the position where native title was discovered and acknowledged, but it was a precarious or usufructory right that could easily be extinguished. And so we come to the decision that was handed down by the High Court this year in Griffith, or the Timber Creek case, as it's now known, in which economic and cultural loss was finally quantified by the High Court. And that's what Tammy is here to talk about. So I'll hand it over to Tammy.
Hi everybody. As Tom said, my name is Tammy. I'm the reader on this floor, and so I'm very happy to be here, and thank you for having me. Today I'm going to be speaking about the history and development of native title in Australian law. Now, it should be acknowledged, obviously, that there were a number of events that preceded Milirrpum and Nabalco that was significant for land rights in Australia. But the reason I'm starting with Milirrpum and Nabalco is because it is recognised as the first case litigated in Australia that dealt with the question of the doctrine of communal native title. So I'm actually going to be using Appendix 2, which is at the back of your papers, as a guide. What I plan to do tonight is to basically go quite quickly through 3-4 decades of native title law between Milirrpum and the Ngaliwurru Nungali case, which is the most recent decision on compensation in native title. And then I'll go on to discuss briefly some of the principles that now stand for the assessment of compensation in cases where native title is extinguished. So to start with Milirrpum and Nabalco, this case was brought about because in the 1950s to 60s in northeast Arnhem Land, the Commonwealth Government was in discussions with a company called Nabalco that was now known as Rio Tinto, Alcan. That company was interested in mining bauxite in a particular area that was part of the Yirrkala Aboriginal Reserve. And there were Aboriginal people who lived on that land. So in about the 1960s, the Yolngu peoples that resided in that area, having become apprised of the intention of the Commonwealth to grant a mineral lease to that company called Nabalco, put together the famous bark petitions and presented them to the Commonwealth Parliament. And those bark petitions asserted in part that there were Indigenous inhabitants that lived in that area, that they asserted a right to live there and to use that land for their livelihood and for their residence, and that the Commonwealth acted without due consultation when deciding or intending to decide to grant rights to Nabalco. And one of the other things that that petition spoke to was a request for the Commonwealth to consult with the Indigenous peoples living in that area before granting the lease. And so, despite the Parliament's acceptance of those petitions, and despite the convening of a select committee on the question of consultation, in 1968, the Commonwealth nevertheless granted a special mineral lease to Nabalco. And so in 1971, the Yolngu peoples in northeast Arnhem Land put forward a challenge in the Supreme Court of the Northern Territory to the validity of that special mineral lease and to Nabalco's subsequent activities. Justice Blackburn heard that case, and he found that the doctrine of communal native title did not exist and could not have a place in the Australian common law. And the reason he came to that conclusion was because of accepted English law about what occurs in the application of English law for overseas possessions of the English Parliament. Put another way, there was already settled law in England as to what occurs when the Crown acquires land by way of colonisation. And that land was categorised in two different ways. The first was where the land had a recognisable system of law already within that land and already submitted to by the persons living in that land. And so in those cases, colonisation was characterised as a conquering of the land or where the land had been ceded to the Crown. And in those cases, the Crown recognised that the local laws of the people already living in that land persisted and were to continue having force unless the Crown changed the laws or enacted laws that were inconsistent with the local laws. The second category of colonised lands were those known as settled or occupied colonies. And in those lands, the common law did not recognise that there was any established system of law in place. And for that reason, English law applied from the time of colonisation. So Justice Blackburn applied the authority. He felt bound by cases such as Cooper and Stewart and by the commentaries in Blackstone to find that Australia was a settled or occupied colony. And what that meant was that notwithstanding the presence of Aboriginal people living in Australia, and notwithstanding that they had customs and laws, he found that those laws were not capable of recognition by the English law. And in that sense, there was a legal void. And into that void came the English law and also the absolute title to the Crown as a result. By contrast, actually I might leave that for later. So when the plaintiffs in Milirrpum pleaded that their system of law survived the act of colonisation and those rights in native title ought to be recognised notwithstanding the act of colonisation, they also asserted that the native title rights were proprietary in nature. And so it's interesting because after having listened to extensive evidence from the Yolngu witnesses in that case, Blackburn concluded actually that he had to recognise that a system of law was in place. So it wasn't that there wasn't anything, it was just completely empty, but just that the question then became for him whether or not that system of law was recognisable by the common law. He found against that proposition, and primarily because he did not see that there was a sufficient nexus between the way that the Aboriginal people in North East Arnhem Land conceived of their property rights, between that conception and the way that proprietary rights were understood in the common law. And I'm going to just briefly give two examples of these differences which were put forward in Milirrpum. The first is that in that particular case, the people in North East Arnhem Land explained to Justice Blackburn that the way they considered property rights, or their rights in native title, was with reference to a concept called moiety. And imperfectly put, and simplistically put, the idea of moiety is that everything in the world, the Yolngu world, in that area, is split into two different categories. And those are known as Dua and Yirija. So for example, a particular area is Dua, but maybe a particular object on that area, such as a land feature, might be known as Yirija. And what they understood was that native title interests derived from the individual's connection with those particular moieties. And secondly, the native title claimants put to His Honour that their kinship and their clan systems were also patrilineally linked, so that you would inherit your right in native title through patrilineal descent. His Honour found that some of these concepts, and there are more, were just not sufficiently connected to the common law of property, and he didn't think, therefore, that they translated. So, skipping forward a couple of years, about 15 or so, we come to Mabo in Queensland. And I'm going to speak on the Racial Discrimination Act in that context, so we'll just skip that circle for now. In Mabo, the High Court overturned the decision in Milirrpum on the basis, really, on my reading, that the common law, it was necessary for the common law to develop in view of the developments in society up to that point. So by the time we got to 1992, the Racial Discrimination Act had been enacted in Australia. Australia had become signatory to international treaties like the ICCPR, which recognised that discrimination on the basis of race was not acceptable and unlawful. So I want to put forward a couple of key points in Mabo. And here on page 3 of the paper. The High Court ruled that the so-called feudal theory, which I described earlier as being that theory of colonies being put into one of two categories, one of which would allow local laws to persist, and the other one which was essentially terra nullius, where even if there were people on the land, the common law didn't recognise their local laws. So the High Court describes that notion as the feudal theory, and they reject that theory in Mabo because the basis of such theories, quote, depended on a discriminatory denigration of Indigenous inhabitants, their social organisation and customs, and were false in fact and unacceptable in our society. And the High Court was really faced at this point with an assessment of how Justice Blackburn came to his decision. And essentially what the High Court said was, well, if we're going to continue on with that line of reasoning, we're going to have to engage in assessment of whether or not the laws and customs of Indigenous peoples was sufficiently sophisticated so as to allow the common law to recognise them. And the justices in the High Court held that such an assessment was very much out of step with where society was at the time, and it was discriminatory, and it had no place in contemporary law. And so they set aside or discarded that entire body of theory, and basically said that there was no longer going to be a distinction between inhabited colonies that were terra nullius and those that were not, but rather native title did exist, and that it did persist despite the colonisation of Australia in 1788. The High Court also found, well, I might just mention as well that the justices in the High Court were very careful to say that notwithstanding the social and historical developments to Australia as a society where racial discrimination, etc., no longer was acceptable, that the recognition of native title could not fracture the legal skeleton of Australia. So they really assessed how, if native title existed as a concept, how it could fit in with the common law without disturbing the rubric of what already existed. And in that context, they found that rather than obtaining absolute title over land upon colonisation, the Crown had rather what is known as radical or ultimate title, upon which native title rights were a burden. And they found that was entirely consistent with the recognition and existence of native title rights, and no inconsistency arose. And so in Mabo, the effect of Mabo was to set out, number one, that native title rights did exist at the time of colonisation. Number two, that they survived. Number three, that they were a burden on the Crown's radical or ultimate title. And number four, that where the claimant group could prove a traditional connection with the land, and I'll just move to that particular quote on page 3, where a clan or group has continued to acknowledge the laws and, so far as practicable, to observe the customs based on the traditions of that clan or group, whereby their traditional connection with the land has been substantially maintained, the traditional community title of that clan or group can be said to remain in existence. However, when the tide of history has washed away any real acknowledgement of traditional law and any real observance of traditional customs, the foundation of native title has disappeared. And that is the fifth key outcome of the Mabo decision, which is that the acts of the Crown can have the effect of extinguishing native title. So to take a little leap back in history, before Mabo versus Queensland number 2, there was Mabo and Queensland number 1. And essentially what happened was there was a law. So the claimants in the group brought their claim in native title over a particular area, the Mir Islands in Queensland. A couple of years after that claim was brought, the Queensland government enacted legislation which essentially vested those rights in those islands in the Queensland government, and then pleaded that as a defence in the Mabo case. And the plaintiffs demurred, and the High Court extracted that particular question and heard it first on the assumption that native title rights could be proven. And what was found was that because of Section 10 of the 1975 Racial Discrimination Act, if the inhabitants of the Mir Islands could prove that they had native title, that native title was a proprietary right. If it was a proprietary right, then it was a right within the meaning of Section 10 of the Racial Discrimination Act. Section 10 of the Racial Discrimination Act prohibits, provides that all persons have a right to enjoy the rights, including proprietary rights. And so what the High Court found in Mabo number 1 was if native title had been extinguished, or otherwise impinged upon, that was an act of discrimination pursuant to Section 10 and was therefore invalid. And so arising from that backdrop where Mabo number 2 was successful, it then became part of the law of Australia that where native title existed and a state or territory law sought to impinge or remove that title, those acts were invalid to the extent that they contravened the Racial Discrimination Act. And that brings us to the Native Title Act. This act was enacted in 1993, and it had a commencement date of the 1st of January 1994. Basically, what this act sought to do was put the decision in Mabo into legislative terms, because the High Court, having found that native title existed and having found that it could be extinguished, the Parliament recognised the need to enact legislation that dealt with this proprietary right. The Act is complex, but in general and broad terms, it provides a process by which native title rights can be recognised, and it also provides the ways in which native title may be extinguished, and it provides for the validation of past acts which may have been invalid, and I'm going to go into that shortly. And it also provides for compensation where native title has been extinguished, and also provides a future regime for the protection of native title rights. So it's important to understand the validation regime within the Native Title Act, because practically speaking, when the Racial Discrimination Act was enacted in 1975, the legislators didn't know that in 1992 the case of Mabo would be handed down. And they didn't know that because of Mabo number 2, a whole series of acts put into place by state and territory governments would become invalid pursuant to the Racial Discrimination Act. And these acts include, for example, the construction of public works, the granting of freehold title, the granting of commercial leases, granting of pastoral leases, and it would have been complicated if all of those acts then became invalid, because for a good 20 years people had been living their lives in accordance with the understanding that those acts were valid. And so the Native Title Act provides for a system whereby each of those acts can be validated. And so in consequence, states and territories passed legislation which so validated those acts, which would have otherwise been invalid which would have otherwise been valid if native title didn't exist. The Act provides that where a past act is validated, it has a certain legal effect. And that effect is either extinguishment of native title, partial extinguishment of native title, or otherwise it has no effect, or it has a suspending effect on native title. And Section 51 of the Act, importantly, provides for compensation and provides that there's an entitlement on just terms to compensate the native title holders for any loss, diminution, impairment or other effect of the Act on their native title rights and interests. And so potentially at the point of the enactment of the Native Title Act, and where state and territory governments subsequently validated a whole number of acts that impinged upon native title, there arose a number of potential actions for compensation. As a side note, which I won't go into in too much detail, but you'll see in Appendix 2 that there are a number of square brackets with the words PA, IA and FA on them. In very simple terms, all that happened was that the Native Title Act prescribed a regime for past acts and future acts, past acts being acts that happened before the enactment of the Native Title Act and its commencement in 1994, but after the Racial Discrimination Act in 1975, and future acts being all acts before after 1994. The reason there's a small section labelled IA is because a case called Wick Peoples and Queensland found that pastoral leases did not necessarily have the effect of extinguishing native title, and as a response in 1998 the Parliament enacted the Native Title Amendment Act and inserted a new category of acts called intermediate acts, which fit between the time of Mabo and the decision in Wick in 1996, which provides for things like pastoral leases and the effect that they might have on the extinguishment of native title. So since the commencement of the Act in January 1994, the content of native title and the ways it may be distinguished has become clearer as a result of litigation. I've set out some of the key principles on pages 4 and 5, and I'm not going to go into them in detail outside of noting that as each case has built on the other, the rubric of native title has become clearer. So, for example, in the case of Yanna and Eaton, which is one of the earlier cases in 1999, an Aboriginal man hunted a crocodile, and the question before the court was whether or not the hunting of that crocodile was a native title interest or a right that he had in native title. And it was found that it was. And also, interestingly, it was found that if he had hunted that crocodile by non-traditional means, so if he'd done it with modern means, that would have also been something that was covered in his native title rights, because it allowed for the progression of society from the time of old. Yanna and Eaton also stands for the proposition that native title may only be extinguished where the legislation evinces a clear and plain intention to do so. Native title rights can exist in relation to the sea and seabed, but those rights are non-exclusive in nature. Native title comprises a bundle of rights, and so each right in the bundle is subject to extinguishment. And that's important in the context of compensation, because we're not just considering native title as a block of rights, but we're attaching a value to each aspect of that bundle of rights. Importantly, and this is point 7, Section 223 of the Native Title Act has a whole series of interlocking elements that come together to create that native title right in its definition. In Yorta Yorta, it was found that native title rights and interests must derive from laws and customs acknowledged and observed and possessed by a society under a normative system of law. So it's not enough to identify that there are laws and customs in existence. it's also important to identify that the rights and interests are derived from that system. And if the laws and customs in society existed at the time sovereignty was acquired, and substantially the same laws and customs have been continuously acknowledged and observed by society, the rights and interests will be recognised and protected. This requirement for connection has defeated many a native title claim, and this is particularly so in heavily populated areas or heavily developed areas, such as was found in Riskin Northern Territory and also in the first judgment of Bennell, because it's become difficult for Aboriginal claimants, even if they are successful in proving the system of law, to prove that the connection has endured and the laws and customs have been continuously observed and are essentially the same as they were at the point of colonisation. So I'm going to turn now to the so-called history of compensation cases in native title. It's a bit of a misnomer, because really the case that was recently decided is the first case that sets out the principles for compensation. But it is important to note that in 2006, Django and the Northern Territory was brought as a compensation claim before the Federal Court of Australia. This claim concerned the town of Yolngu, which is a town that's close to Uluru in the Central Desert. And the issue here was that the claimants had not, at that point, been recognised as native title holders over that town and over that particular area. And so that was a prerequisite for the question of compensation to be discussed or adjudicated upon by the court. And so the court ultimately found that those claimants did not prove that the laws and customs and society existed at the time that sovereignty was acquired, and also found basically that they couldn't make out their case as native title holders, and therefore the court did not have to consider the question of compensation at all. So that for that reason the claim failed. In 2013, the first determination of native title compensation was made in the case of DeRose in state of South Australia, where a group of claimants asserted a claim over certain land in northwest South Australia. This is properly the first case that concerns compensation in native title, but it was determined by consent, and the terms of that settlement were confidential. And so no guidance really was derived from that case, only the precedent that compensation could be awarded. So that's what brings us now to the Ngaliwurru Nungali case. In the context of what I've been speaking about, the significance of this case really can't be overstated. If there are seminal cases from decade to decade in native title, this is one of them. And the reason for that is because it represents the first and only expression of judicial guidance on the topic of compensation pursuant to the Act. It's the first time the court has been called to adjudicate and has published reasons on how Section 51 of the Act operates. And to remind us all, Section 51 of the Act states, when I can find it, that there is an entitlement on just terms to compensate the native title holders for any loss, diminution, impairment, or other effect of the Act on their native title rights and interests. So it's the first time the High Court has been called on to define what it means, for example, for native title holders to experience loss, diminution, impairment, and also, importantly, what it means or other effect, and what those claims might look like. So the town of Timber Creek is located about 600 kilometres southwest of Darwin. And if you look at Appendix 1, you'll see that I've put out a map. It shows where Timber Creek is. It also shows where the site of Milirrpum and Nabalco was in East Arnhem Land. So that's the area generally where this community is located. And the claimants in Timber Creek brought a claim for compensation pursuant to 53 past acts, basically grants of freehold or leases by the Northern Territory government which extinguished native title. The claimants sought compensation for each of those acts, compensation for economic loss, compensation for non-economic loss, and compound interest in respect of the economic loss. It's a significant case because it went through the federal court in the first instance and then the full federal court and went to the High Court. But despite each of these stages of litigation, each of those courts upheld Justice Mansfield's original conception of original formulation of how compensation for non-economic loss ought to be assessed, and each of the courts upheld that his figure of $1.3 million for the loss of native title was an appropriate award. So at each point, the Commonwealth and the Northern Territory sought to have the courts reduce the sum for economic and non-economic loss. They were successful each time in respect of economic loss, but unsuccessful each time in respect of non-economic loss. And that has important ramifications because essentially the manner in which Justice Mansfield formulated the assessment for non-economic loss remains undisturbed and was actually affirmed by the High Court. So to deal with economic loss first, the High Court affirmed that courts should take a bifurcated approach to valuation, and that is to separate the questions of economic loss and non-economic loss. The High Court also found that the inalienability of native title rights and interests did not have the effect of diminishing their value. So basically, and I was skipping a couple of points down, the High Court affirmed the appropriateness of the adapted Spencer test when it comes to assessing non-economic loss, which asks what price a willing but not anxious purchaser would pay to a willing but not anxious vendor in a hypothetical transaction. Justice Edelman, in his judgment, does point out that it's somewhat artificial to formulate the test in that way because the nature of native title is such that the native title holders would not ever have fulfilled the definition of a willing but not anxious vendor. But the High Court nevertheless upheld that it was an appropriate test. And so in that context, the courts were engaged in the process of valuing if that native title right had been a freehold right, how much would it be worth? And what factors would inform the assessment of that worth? And the Commonwealth and the Northern Territory put forward all sorts of arguments as to why those parcels of land should be discounted in their value. So amongst those, for example, that it didn't matter, amongst those that because those rights were inalienable, they therefore weren't worth as much as if they were alienable, and therefore the cost should have been reduced, etc. And even though the High Court didn't accept that particular formulation, they did accept other formulations, and that's why the economic loss was gradually reduced from 2.2 from about 3.3 down to 2.5 million. Now, turning to non-economic loss. One final thing I should say, that the nature of native title rights, including whether they were usufructuary, ceremonial, non-exclusive, or conferred the power to grant coexisting rights and interests, or included the right to exploit the land, were all relevant considerations in assessment for economic value. So there were arguments put forward on behalf of the claimants that those rights, that the amount for the loss of those rights should be increased for various reasons, but the court held that in the absence, for example, of evidence that showed that the claimant group could use that land or would have used that land for commercial purposes or would have exploited it for other reasons, it wasn't appropriate to value those rights as if they had that character. So now I'm going to turn to the non-economic rights. And Justice Blackburn, I think, in a very compelling metaphor, said in his first judgment that the non-economic loss of native title should not be measured act by act in isolation. And that was a submission that was put forward by both the Commonwealth and the Northern Territory, that each of the acts should be considered in isolation, and they should be considered in the context of the land on which they occurred. So rather than considering the effect of that act in globo on native title and those rights as enjoyed by the people, the native title holders, it should rather be a much more pinpointed and specific analysis. And Justice Mansfield rejected that reasoning, and he likened it to putting holes in a painting. And basically he said, if you put holes in a painting, the effect upon that painting ought to be looked at holistically. It's not that that particular act of putting a hole in the painting causes loss, because it does, but on top of that, it's in connection to all of the other holes in the painting, and the loss that people would, that the claimants would feel in considering their native title rights as a whole. And on that point, he found, and it was affirmed, that consequences of acts can be incremental and cumulative and should be assessed in the context of their wider effect on native title. And so, in conclusion, I might just say that the development of native title law has really come a long way since Milirrpum and Nabalco. In the first instance, there was a finding of no native title and therefore definitely no compensation. And then in Mabo, it was held that there was native title, but actually a majority of the court found that there was no compensation for extinguishment. So the concept of compensation really arose in its clearest form by Section 51 in the Native Title Act. And so now with the Ngaliwurru Nungali case, there's a quantification of that compensation and therefore a quantification of the value of native title. And importantly, the value of the cultural significance, the religious and spiritual significance of that title to the Indigenous inhabitants of the land. And so for that reason, it's a very significant case, and I think this area is going to be the subject of much litigation in future. So thanks for your attention.